Okay, we now open it up for question answers. We would like to ask you to wait for the mic, please, and pass the mic around across the room.
Thanks for a very enlightening session here. Sir, our resolve lies in the fact that you do this thankless job again and again for Moneylife. Thanks so much. Sir, my question was...
Only one small correction. I have been thanked so much, so it cannot be thankless.
Fine. The fact that you just mentioned that, transmission of shares is very important, which has been highlighted under Section 109A now. It's very clear. As far as the other three acts are concerned, that is Maharashtra Housing Act, the banking and the insurance, how does the nominee go? Especially in case where there is a probate or there isn't a probate, and is there, in case where there is a tester and there is an intestate situation. How do you resolve that?
See, so far as nominations are concerned, in respect of banking, insurance and Maharashtra State Cooperative Housing Society, it is very clear the only intention of nomination is that the concerned agency, whether it is the bank or the insurance company or the society, stands discharged from its duty once it has recognized the nominee. But so far as the property is concerned, whether it is in respect of the amount in the bank account, or it is in respect of the insurance amount, or it is in respect of the apartment in the cooperative society, will be decided by court of law if there are claimants. What has happened in the context of the company, as I said, if the nomination is filed, then the nominee himself is treated as the owner for all practical purposes. And that arises because from the words mentioned that all the rights vest when they get into the hands of the nominee and to the exclusion of all others. These two phrases together have given total power to the nominee. In effect, the nominee becomes the owner, whereas in all the other three cases, nominee continues to be the trustee. And trustee's job is to hold the property in trust, and only after that, when the court has decided who are the legitimate owners. Now it could be that nominee and the owner could be same also. Suppose it is my son and 100% property, he is the nominee and he is the legal heir. It can coincide. But we are talking of a case where nominee need not necessarily be the whole owner or not even a partial owner, but the intention is to make him a trustee. And because of that understanding, somebody makes him a nominee in respect of shares. But in reality, he will become an owner. And there will be a job on the hand. And very clearly, in light of this judgment, one has to be very clear. And in this context, let me also say it is always advantageous if you intend to make somebody owner of a particular property, that is legal heir who will be entitled, or you want your will for your child, then let the nominee also be the same person. In one case, nominee was A and in the will it was mentioned for B. And when went to the bank said why it is so. That you are supposed to be the nominee, but here again you are not entitled. So these issues, if can be avoided, it is always better. Well, as it is, as I said, a lot of issues will arise after death. Try and synchronize, because sometimes, this is again the experience, that testator feels that he or she also should put some checks and balances on some relatives to see that whether the executor or other should not take total liberty. And that's why many times they like to have two executors, so that again there could be a check and balance on each other kind of a thing. I hope I answered your question.
Excuse me please. In the event of a nominee having settled abroad, upon the death of the testator, what are the taxes that the nominee will have to pay? Clear up. Am I clear?
Nominee, taxes on death.
Yes.
At the moment, fortunately, there are no taxes. Estate duty is not there.
No wealth tax,
So
no
there will be
estate
no
tax.
taxes on that. No, on death it will be estate duty, which is not there.
Yes. Thank you.
Can a beneficiary be an executor as well? And secondly, can a beneficiary or an executor attest the will?
See, it is always advisable, as I said, in law, nothing is provided. There is no bar. And executor can be, as I said, nominee also, because, as I said, suppose only child, whether son or daughter, only child, and you are going to give everything to the child, then that child can be herself or himself be the executor. There is no bar on that. And in such cases it may be helpful also, because outside executor may pose problems for the child. That is also possible. And secondly, it is always better that if your attestation is done by a non-executor, that will be better.
Sir, my question is, now you just said that there is no duty, estate duty applicable. But supposing I have a flat today costing 2 crores and I transmit by will to my sister, or I do a settlement deed today, what will be the overall advantage to my sister? Because I have been told that after I die, and if I will it to my sister, she will have to pay some registration or transmission fees. I don't know how much that would be. I'm told it could be as much as 10%. But if I do a settlement deed today, I hold it till the rights till I am alive, and there is a clause where it gets transmitted to her automatically with the savings of a transmission duty or whatever it could be.
No, when you are doing through the will, on the contrary, there is no question of duty being payable at that time, because there is no transfer involved. See, when that is a transmission which takes place by virtue of a will, there is no duty involved because there is no transfer. That is very clear.
So there won't be any taxes in probating, etc.
No, see, probate, let us not mix up two issues. When you buy a property or you gift a property, then as per the conveyance rule, the conveyance deed is drawn up and duty is payable. And if it is a relative, then there is some concession given, 2% to be paid or whatever. When by virtue of a will, that property is inherited and that has to be probated, probate fees are a separate issue. That will go by whatever court rules are there and whatever fees is payable in the court. That has to be paid.
Is it on the percentage of the value of the property?
Yeah, but there is an upper limit also.
Yeah, okay. Fine.
So
not to worry.
That is not really to worry.
Not to worry.
That is why, in fact, many times planning is done through the will.
Okay, got it.
So that you don't create documentation today, because that may amount to a conveyance today and raise issues about stamp duty.
Second question is, how to avoid this legal problem? Supposing a sister makes a will in my favor, she writes everything, she even registers it, even a doctor has certified it. Still, how to prevent a legal problem?
Let me tell you, when there are lawyers, you cannot avoid legal problems. No, the fact is, we are such a litigating society that we don't even need an excuse to rush to court of law. So, if somebody wants to challenge, then definitely one can challenge. But remember, even whoever wants to challenge, there is a cost involved, there is time involved, there is effort involved, and then of course there should be legal legitimacy available to him. Some fig leaf should be there by virtue of which he is entitled. If there is no entitlement, he may only harass you for some time, but he will have to bear the cost also, and you may have the last laugh.
Sir, can a registered will be replaced by a last will on plain paper?
Sorry?
Can a registered will be replaced by last will on plain paper?
See, as I said earlier also, registered will only indicates that on that day, that will was registered, and that means it was made either on that day or before that day. But every day, as I said, till the date of death, one can keep on making a will, and will is made on plain paper. So eventually, if two or more wills come up before the court of law, the job before the court is which is the last will and testament. That's why the phrase that this is my last will and testament. I might have made, I might have got registered, but today this is my last will and testament, and it is invariably on a plain paper. There is no specific paper for that as such.
Thank you very much for the show. So I just want to clarify, at the start you mentioned that if there are joint holders in shares of the company, if the first name holder passes away,
Sorry? I think their contract is loose or something.
Listen, get the mic. We'll finish this question.
Sorry. Hello?
Yeah.
Thank you very much for a nice talk. So at the beginning, you mentioned that if we have joint names in a share in a company, for example, and the first holder passes away or the second, whoever, the shares would automatically go to the remaining one. However, if there's a will, could you please clarify if the will supersedes the joint pattern of holding? That's my query.
Yeah, I'll explain to you.
Thank you.
See, in case of a company, when there is a joint shareholder and the first name or the second name, whoever shareholder passes away, then automatically the shares stand transmitted in the name of the surviving shareholder. A death certificate copy has to be produced before the company, and they will delete the name of the deceased shareholder, and the shares will stand transmitted. Suppose there are 3 shareholders, if one dies, the remaining 2, or if 2 die, the remaining 1 shareholder, they automatically stand transmitted. Now, so far as the ownership is concerned, whether he is the owner or not, company will not bother, it is not company's botheration. If the surviving shareholder is not the owner and someone else claims the ownership, then it is a fight between those two, the shareholder and the claimant. That could be an independent thing. For example, A, B and C. Now A is supposed to be the 100% owner, B and C are only joint shareholders for namesake. A dies, B and C as such are not entitled for argument's sake. It is D who is entitled. But company will recognize B and C because they are the shareholders, so far as the company is concerned. But so far as the ownership is concerned, D will have to go to court of law, file a suit and claim his right over those shares, that the ownership belongs to him and they are only nominal holders in the records of the company. So that becomes a totally independent issue. I hope I have answered your point.
So you've answered, but you know, with today DMAT, names being in a particular order, it's not necessary. I may have my shares with me, A and B, but when it comes to my will, I would like my estate, including my shares, to be distributed equally between X, Y and Z. So then what happens to these shares?
That is why one I said that you can only dispose of what is your own property. If it is your own property, then one would be try to have joint holders who are going to be your legal heirs also, so that you create less complications later on. Later on, if dispute arise, then invariably, let me give you a simple example. Suppose I am the joint owner and the shareholder dies. He was 100% owner, and I decide no, he is no more there, and I say it is my property. And company will not come into picture. Company says, yes, as per record, you are the surviving shareholder, and we have transmitted shares in your name. Then I will say, okay, if you are claiming it is your property, get me an order from court of law. Then he will have to go to court and claim and prove the title and then get the right. That's the point. Thank you.
I have a question as regards provisions of section 109 which you mentioned and Bombay High Court decision. In my will, if I say that I have nominated Mr. So-and-so merely as a trustee and not the owner, how will it be taken?
First of all, let me clarify, I think I didn't say at that time, that in this judgment there was no will. It was intestate. And the widow was claiming as the widow of the shareholder, but the judge very clearly said that nomination is superior. Now, so far as your will is concerned, here there is a statutory provision which vests all the powers. Now, court has already given a judgment saying that is so. So this will become a legal issue per se automatically. It would not mean that nominee is out. Nominee is very much in the control, and you will, the survivor will have to, legal heir will have to raise an issue before court of law that through the will, the nominee's role has been curtailed, and therefore, then the question will be, can the statutorily provided provision be curtailed by individual through his will? Chances are that the answer will be in favor of the nominee. That because the statutory role is there to the exclusion of all persons. So I would say, instead of complicating, as I keep on saying, have the person whom you would like to have a legal heir as your nominee. That will be much easier.
In other words, you would not advise, or it will not serve any purpose if I specify specifically in my will that the intention is not to pass on the property.
See, as I advise even while talking, that draft a simple document, avoid creating complications.
Okay.
As it is, there will be enough complications. Try to minimize those.
Okay, one more question and last one. Last one, this is in regard to succession. If a sole, if the shares are registered in a sole name,
right,
and the person expires,
right,
but there is a will, and because of the will, the beneficiaries are specified,
right,
or there may be only single beneficiary.
right.
Can transmission take place based on the will?
No, generally it is for the companies to decide. Some companies, if the number of shares involved is small and there are no issues, problems, beneficiaries themselves give no objection to be transmitted in favor of one or all jointly, then the company may agree. But suppose the number of shares is more, company may not take chance, they may ask you to get a succession certificate from a court of law, and then only they will consider. Otherwise, some company, even 100 shares are there, they can refuse, saying that either have a probate or a succession certificate. Otherwise, we are doing nothing. And in this, banks can be horrible. Even for small amounts, they can refuse it point blank as such, that get a succession certificate from a court of law. And sometimes there are differences, then one brother or sister may go there and tell them that they are not entitled, I am also entitled. Banker will quietly sit, that's it.
Hello. Good evening, sir. My name is Lata. I really liked your talk, especially when it was peppered with all those quotations, and I like that quote about traveling light. You know, it gives new philosophy to life being a journey. Okay, now my question is to do with property. I was under the impression that when a property, any immovable property by two or more people, and upon the demise of one, it automatically goes to the others. Is that true? Because I under the Hindu Succession Act or some laws, property laws, that was what one lawyer told me.
Right.
So,
Because from joint owner, it becomes a single owner.
yes.
But the issue arises if there are people who want to challenge, if no will is, suppose the will is left,
Yes.
and it is very clearly mentioned that this property was jointly owned, my share also goes to my spouse, etc.
Right.
No issues.
Okay.
But if will is not left,
Yes.
then to the extent of the share of that person,
Yes.
challenge will come on that.
Yes.
That will be the thing.
Yeah, that is exactly the question I want to ask.
So
I
if-
want clarity on that.
If let me say, I and my wife, we are joint owners,
Yes.
50% is mine,
Yes.
50% is my wife's,
Right.
and she is a joint holder. So far as the government records are concerned,
Yes.
it may become an individual owner, because I am no more, so my wife becomes the individual owner. But so far as the right in that property is concerned totally, that my share, because I did not leave a will, could be open to challenge. That my children, my other relatives, whoever believes he is entitled, can create a challenge. But if my will also states that this my share, which is 50% in that property, goes totally to my wife, then there is no problem.
Yes, but somebody, a lawyer, a noted lawyer told me, notwithstanding the fact that there is a will, the property will still go to the joint to the survivor.
Property automatically goes. That's what I'm saying. Property automatically goes because the joints are like in case of company shares.
Yes.
Automatically the joint shareholder becomes the surviving shareholder,
Right.
and is entitled. See, there are two aspects.
Yeah.
One is in-law who remains the owner, and then question is whether there can be a challenge or not. That is an independent issue. So
Yes.
challenge could always be there in certain circumstances, but that does not take away from the fact that the joint owner becomes the absolute single
Yes.
owner unless
Yes.
dislodged by a court of law. Then only.
Yes,
Otherwise
but
nobody can disturb.
the question here is, if the joint holder becomes the sole owner of the property, then my will becomes redundant. It might as well not have been there, because if it is going to be superseded by the law, then how does my will stand any judgment in court?
No,
how
if,
would it?
if will is already made,
Yes.
as I said, if my will is there, then my wife gets 100% in law also.
Yes. But
Whatever the challenge.
if I have billed my property, my share of the property to a person other than my spouse, then what's the legal standing?
Yeah, I didn't get your point.
See, let's say a joint holder, husband, wife are 50-50. Oh, no, okay, all right.
Question. Hello. Yeah. My question is that if a testator is writing a will and all the properties, investments and shares are in India, and he is giving beneficiaries are in US where the estate tax is levied, so what would be the point of time? If beneficiaries and all say all two sons are in US and the testator is in India, all properties and investment and shares are in India,
Right.
and all the beneficiaries are in US.
Right.
In India there is no estate tax or inheritance tax, but in US estate tax is levied. So in that case, if it is inherited in the property is going to a person who is an US citizen, in that case what was the situation?
Now one thing I can tell you, I'm not an expert on US laws. Not that I'm an expert on Indian laws also, because that is not my forte. But the properties are located in India, so it will go by the laws of India here. Thereafter, if property is transferred there by selling here or the funds there, then they have to go as per the US law as such. But so far as the property is located in India, the Indian law will apply. No, that's you are inheriting the properties which are located in India, so you have to apply it will be US citizen, that is not the point. But it will go by the Indian law so far as the tax or anything is concerned as such.
One small question about a only child of a father. Does it make any difference whether a will is made or the man dies intestate? Because the taking out of probate also in actual practice involves the same complications as taking a succession certificate. What difference does it make?
Now at one level, yes, it is true. Only thing is that when question is kept open, then a lot of people can easily challenge. That is the main thing if there is no will as such. But you are right, if will also somebody can challenge, but will then chances have to be assessed to what extent one can succeed. Although when we go for a probate, one can create issues. But without a will, the thing can be much more lengthier. It can take much more time till you arrive at the same conclusion which you can arrive in a probate comparatively faster. That is the only thing as such.
Hello. Sir, this is a case of one of my friend. Her father died leaving physical shares. She's now got the succession certificate in place. Now she should approach the transfer agents or the registrars or the company itself to get the shares transferred in her name.
See, some companies they write for all this you directly contact the R&D agent. But legally, if you send to the registered office of the company, it is company's duty to ensure that it is forwarded to the R&D agent and the needful done as such. So you can send to R&D agent, you can send to the registered office of the company also.
Can she directly approach the depository services to get a demat and they will transmit in her name? Is that possible?
No. First you will have to send to the company.
Okay.
Physical shares you have to send to the company.
मैं अपना सवाल हिंदी में पूछूंगा इसरानी जी। मान लीजिए ए एंड बी दो ओनर हैं, ए एक्सपायर हो गए, विल में लिखा हुआ है कि बी को संपत्ति मिलेगी, तो बी को संपत्ति मिल जाने के बाद उसको रजिस्ट्रेशन कराने अनिवार्य है क्या, और अनिवार्य होगा तो क्या प्रोबेट लेना जरूरी है क्या?
जहाँ तक रजिस्ट्रेशन का सवाल है, you have to go for probate, otherwise the registering authorities may refuse.
और सक्सेशन सर्टिफिकेट लिया जा सकता है क्या?
Now probate is basically started in the presidency areas, Bombay, Madras and Calcutta. There generally the will is probated. Elsewhere you get letter of administration or succession certificate.
अच्छा. और एक ऐसा केस है जिसके अंदर ए और बी हैं, ए के नाम की संपत्ति है, बी का इनकम टैक्स में कुछ नहीं, इनकम टैक्स में ए के नाम की संपत्ति है, तो जॉइंट नेम में प्रॉपर्टी पड़ी है, तो क्या वो ऑटोमेटिकली विल नहीं है तो 100% उसके नाम सेकंड नाम पे जाएगा क्या?
Now so far as the record is concerned, joint owner automatically surviving owner becomes the owner. And if he is not entitled या उनकी जो lack of entitlement is there, then whoever wants to challenge, who is entitled or who believes is a legal heir, then has to challenge that.
Because in income tax, A is the only owner. The whole property have been declared in income tax written by the A.
Yeah, so it will be presumed in law that property was owned by him, the other one was a nominal owner as such.
In that case, what will happen? There is no will.
No, that's what I'm saying, it will again go to a court of law if somebody is challenging that as such.
Sir, this question is about a Hindu male who has died intestate and kept his wife as a nominee for his apartment. So my question is, like, how long can his spouse be a nominee, and will it affect the rights of the legal heirs over a period of time if nothing is done? It's just kept as a nominee in the society records.
See, societies normally on the basis of nomination also, they give membership. They may ask you for a copy of the will if it is there. If it is not there, then generally societies, they take precaution they release public notice that anybody has objection, so that they would like to see if there are any claimants or anything. The minimum job is done by the society to ensure that they have not been negligent, so they issue public notice. Thereafter, nominee is enrolled as a member. Membership by itself does not mean ownership. So when the issue arises, then that's it. If there are no claimants, it is fine.
There are claimants, there are other legal heirs as per Hindu Succession Act.
Right.
Silent for a period of time, maybe years put together, will it affect their rights?
Now let me tell you, recently I came to know a 32-year-old probate was reopened by Andhra Pradesh High Court. Although probated, after 32 years said no limitation. That time the person realized or he had a need and therefore it could be done, there is no limitation, the court has said.
So the rights of the legal heirs are not affected in any way, even if
So I would not make an absolute statement that they are not affected. The person who claims has to make out a case why he woke up from Kumbhakarna sleep at that time, and if the court is satisfied, then court may grant relief.
Thank you, sir.
This is regarding Maharashtra State Cooperative Societies Act. I am having a flat in my wife's name. Taxability sake it is on wife's flat. I am a joint holder of the flat. In Maharashtra Cooperative Societies Act, these days, old days actually joint shareholder was considered to be the next person actually who can have the flat in his name.
Right.
Now they say that since the first person actually is the owner, the flat may be on other two persons actually, say wife and this husband and son. But the husband and son, they are just nominal members.
Right.
The flat will go to the nominee. Now I have made, to simplify the complications, I have made my daughter, because I want to, or all three of us want to see that the flat goes to my daughter.
Okay.
So I have made her as a nominee.
Right.
Now in the presence of all the three, wife, father and son, they are already shareholder actually in Maharashtra Cooperative Societies Act actually and in the share certificate.
Right.
Now somebody has, or I feel actually that in my lifetime it is better to give this flat as a gift to my daughter and avoid all the complications actually in our lifetime when we are alive. So what will be your advice actually? To avoid the complications and not to mention the flat actually in will at all.
Well, honestly, first of all, let me confess, it's very difficult for me to give advice like that as such without getting into the details of things. But in general, I would agree with you. As I said right in the beginning, whatever you can do during your lifetime, it is better rather than keeping it and suffering the pangs later on as such. So, you have thought of in that direction, definitely it is a right thought as such.
Question, how do you take care of HUF? Is it automatically taken care of or you have to specifically mention in the will? Because HUF there is no joint or nomination allowed in shares.
It's only to the extent you are a co-partner, to the extent of your share in the HUF, you can provide for in the will as such. Only to the extent your interest in the HUF. Then whatever is your property under the HUF, you are the karta, you are the creator, then you can accordingly provide for that as such.
Hello sir, you said about this nomination that in case of shares and debenture, the nominee becomes automatically the rightful owner. Does it apply to mutual fund units or fixed deposit of company also?
Now here let me clarify, this is in the context of section 109A of the Companies Act, which talks about shares and debentures. So by implication, mutual fund, fixed deposit are not part of this.
So in that case, even the nominee does not become a rightful owner, you are saying?
So far as those instruments are concerned, if they are mere nominees, that's how the position is. But shares and debentures, it is the section which has provided, and that is where by virtue of their judgment it has come into limelight, and that is the law as such.
Okay. Second thing, the second question is basically you said in spite of having a will there could be complication in the future. So does it make sense of gifting rather than putting it through the will?
See, when I said complications, the point was that always if somebody wants to raise the issue, some legal heirs, they can always raise issues. But at the same time, as I said, whatever if you during lifetime you want to give and you plan to give, then it's always better because that much less will be there for disposal later on through the will. That's the point as such.
Yeah, I want to raise one question. Can a videograph be treated as a will?
No, at the moment the law is about a written will.
Okay, that's all.
Otherwise, once upon a time, oral will also was accepted. But today that is not accepted by law. But just to take that point further, today in some cases even video is being taken for the purpose to show that the testator was hale and hearty and of his own free will and volition the will was made. So that's an additional just evidence to adduce that here is evidence somebody challenges that condition can be shown. It's just a supportive, not primary evidence as such.
Good evening, sir.
Good evening.
Assuming that there is no dispute as to is it necessary to get the will so as to entitle of the...
No, see, very valid question, important question you raised. It is not necessary that in each and every case where there is a will, that every will has to be probated. Probate you go only when you have no choice. That your property, there is a immovable property which you want to get it mutated in the sub-registrar's office. Your name should come there. It will not come unless there is a probate or a letter of administration or a succession certificate.
Or named as the sub-registrar of the assurances. So is it necessary in that case also because society indiscriminately seeks probate?
Now, why do they seek probate? No, disputes, society wouldn't know. See, today suppose let me tell you, I am secretary of the society, which I am not. I am just assuming that there comes a case that there are no disputes, we are wonderful brothers, we are Ram Lakshmans here as such. Then later on you have gone on that basis and done it, and then you receive legal notices. And there are suits filed against it. So society is normally to avoid that, their legal advisor will advise either get NOCs. If they are all Ram Lakshman, there are no issues, get NOCs. So that no problem, don't ask for probate, fine. That this brother, which happens many times, they give NOCs, we have no objection, finished. But if somebody refuses and society knows for sure he has a sister or a brother or anybody who is entitled falling within that degree, why should the society take risk? Society will say go and get probate. That is how it happens.
Sir, if a will is registered and codicil is prepared, is it necessary to be registered again?
As I said, will itself is not necessary to be registered. And of course, you raised a question, valid question, that if the will is registered, does it mean the codicil should be registered?
Yeah.
Not necessarily.
Okay.
Because on the underlying document, it is not necessary to register, even though you are registered. What is important is that codicil should be genuine, but it should be attested in the same manner as the will, as if it is a will, though it is not.
Okay.
Because it is supportive of the will or explanating the will. So it has to be attested duly. Now here let me share with one Supreme Court case was there where the sub-registrar was called home to witness, do the registration because the testator was not well. So on the will itself, in addition, certain things were written. And registrar signed and one more person signed. Question was that whether it is a codicil. If it is a codicil, does it satisfy the criteria of attestation? Then the Supreme Court finally held, I am not going into the details because there is not the time is running out. Supreme Court said the sub-registrar had come there in his official capacity and he was doing his official duty he was not a witness, he was not a attester. His signature was in his capacity as a sub-registrar and not as a attester, and therefore there was only a single witness and it was not adequately attested. It failed as a codicil and it was taken out as such.
My another question is, you said
Maybe there are some others if you don't mind, so that at least others get a chance for. We can have a word afterwards also perhaps.
My name is Ratanlal Purohit. You said so many things. When my parents died, we brothers and sisters made a family agreement, and that was and society accepted it with one indemnity bond, and that was the end of the matter.
Right. That is true, 100% true. Today also it happens. That's why I said NOC, when brothers and sisters sat together, is same thing. They have given their concurrence, their consent, then there is no problem.
Hello. Is it necessary to write all the bank account names and numbers in the will?
Well, again it is your choice. If you want to be that specific, you can certainly be specific. So the idea is, later on, others should be aware where you may mention all my bank accounts. Now, you might be having an account at the earlier place where you are staying and now you are shifted elsewhere. You may have account where you are working. Now, how does somebody know where are the accounts? So perhaps you can make a list, or you may have your own investment register which contains the details of your investments, your bank accounts, where your property is kept, what you kept in your bank locker, where is the bank locker located, etc., etc. Maybe so that things will be simplified for the people behind us.
Yeah, and secondly, about a proprietary concern in a rented premises, who would be the legal heir? Would be the child and the spouse of the proprietor?
Tenancy, landlord will be there to throw out everybody there.
Yeah, okay.
And Supreme Court generally favors the landlords in that case, unless somebody has already been, so to say, a co-tenant, whether the son or daughter or wife or husband, whoever.
But it is the name of the proprietary concern.
That is all, but if he has been also occupying there, at least some kind of a claim he can raise.
Okay.
But otherwise, it will be difficult.
I just want to know, who are the heirs actually as per the Hindu law? Can the brothers be heirs or only the wife and the children?
No, there are categories given. So first would be the spouse, the mother, children.
But suppose somebody dies without making a will, then who can claim? The brothers, everybody can claim.
Yes.
The whole clan.
Exactly. And the different order, if A category is not available, then it goes to B category.
So if A and B is available, then then it doesn't go.
Then they get the entire, the mother, wife, children, they get the property.
That's all. Then the others do not come.
Then others don't come in the picture.
And you just said that we can appoint the child as an executor. If you have an only child, it is better. But suppose you have two children, can you appoint one of the children as an executor?
We can certainly appoint, but at times they lead to issues. So if you can have either both become executors, or one become executor, you are satisfied, it's an individual decision as such. There is nothing legal about that as such.
Okay, but I mean, the child can.
Yes.
Okay, thank you.
हेलो
यस
सर, पगड़ी सिस्टम में अगर समझो पेरेंट्स साथ में उनके तो can deny the right to transfer the property to his son or daughter?
See, per se tenancy is not transferable. Unless landlord is with you, legally then you have to keep on fighting in a court of law and establish your tenancy, that you have a right to continue to occupy that property.
Okay. And if the landlord is not transferring,
you may provide for anybody's name or whatever, but tenancy per se is not transferable.
Okay.
Sir, the depository accounts offer you the option of only one nomination.
Right.
That nomination becomes a final beneficiary.
Right.
Now, how does one overcome this problem in case you want to the benefits to be distributed to more than one beneficiary?
See, either you have different combinations of accounts so that you have 2-3 depository accounts and allocate your shares in those accounts that way as such.
So in one common account, it's not
But
possible.
at the
Or
moment-
can a will supersede that?
No, that's why that has not been tested. Let me tell you very frankly, that has not been tested. What has been tested, 2010 judgment is where intestate was there and the widow claimed that this is my property. There was no will. Now this, when the will comes up, then the issue, although my personal opinion, if you'll ask, I would say the will should prevail because that is the last will and testament. And that is how finally he wanted this property to be disposed of, and that is should happen. Maybe letter of succession or probate, whatever, that's a different issue. But that should prevail in my view if the will is there as such.
Thank you.
But then courts can be funny, you can never be sure.
Sir, one quick question on joint ownership. A and B are the joint owners of the property, the residential flat. And the society also issued a share certificate in the name of A and B. Now A, who is the first named, he is also given a nomination, giving 50% nomination to B and another person. So what would be the state of that particular nomination?
Nomination will be signed jointly by both the members.
No, it's not signed jointly. It's only signed by the first named.
Then how they accepted if it is not signed?
Society accepted that.
It has to be signed by both persons as such.
But in that nomination, A has put the nominee of the second named also.
Okay.
That way.
So what is the point?
The point is what would be the position of the joint ownership that time. Like you said, if something happens to A, then the ownership devolves to B.
See, whenever we talk of such things, there are two aspects to that. Membership is one part and ownership is the other part. Membership, so far as the society is concerned, it will take cognizance and the nominees become the members or nominee becomes a member. But so far as the inter se rights are concerned, that will be governed by, if there is a will, then by the will. If it is will is not there, then by the Succession Act, by the respective personal law. So if the will is there, then it will go by will. If there is no will, then if anybody is claiming, it will be as per the personal law of that person as such. That will be the thing. So always distinguish between membership by itself does not become ownership. If there are co-claimants, suppose one brother has become member, other brother also has equal right. If there is no will saying that it is 100% for A, then B can also claim and go to court of law that as a joint property I am also entitled. My father has not left any will. So that can be there as such. So that's why always distinguish between ownership and membership.
Okay, with this we bring the session to a close. Let's all give Dr. Israni a big hand. And may I please request our friend Nagesh Kini to give him a small bento in appreciation the time that he so willingly spends with us.